All right, we will go ahead and call the House Judiciary Committee meeting to order at this time. We'll begin with a prayer if y'all would like to join me in prayer. Dear Heavenly Father, thank you for this opportunity for us to work together on behalf of the people of Georgia. Please be with us throughout the day. We ask your continued watchful eye over the people of Ukraine, for your blessings on those people as they are going through this tragic invasion. In Jesus' name I pray, amen. So we want to take up the two bills that are on the agenda, and then we have one add-on bill. And the additional bill is from Representative Leverett, who I understand has a scheduling issue this morning, so he may have to run. So we'll go ahead and call his bill first, HB 1068. Representative Leverett.
Thank you, Mr. Chairman.
We can't hear him.
All right, can you hear me?
I hear you.
Why don't you move, or why don't you come up here to the witness chair? And I think we're having a mic issue with your mic. Thanks for letting us know, Representative Bruce.
All righty.
All right, will you give us a test?
Test.
I think that's working. All right, please start over.
All right. Well, as Yogi Bear said, this is going to seem like deja vu all over again, but thank you again, Mr. Chairman, for placing this bill on the agenda today. House Bill 1068, which is LC 44-1877. This arose out of a constituent concern that was expressed to me by an attorney who occasionally has to file lawsuits against the state under the Georgia Tort Claims Act. And under that act, there is a current provision for service of process or notification of the state that you're filing lawsuit, which requires service upon the risk management director of the Department of Administrative Services and service upon the chief executive officer of the particular agency that's involved. As you might imagine, of course, those people are very busy people, and they're not often in their offices when you try to show up and have them served. So it apparently takes a very long time to accomplish service. Although it's not currently provided in statute, there's apparently a practice by which those individuals will designate persons to accept service for them, but it's also sometimes tough to know who that is and where they are and when you can find them. So we've proposed some changes to the service of process statute that basically says that gives a statutory foundation for the appointment of a designee so that it will be actually authorized by law, and a requirement that the designee be in their office at least 3 days a week so that you can find them when you're trying to serve them. It also says you've also got to mail a copy to the Attorney General. That's in current statute. And we have an addition here that just says the Attorney General can acknowledge as well if you just mail to them by regular mail. So that it's fairly simple bill, Mr. Chairman. It just tries to address sort of some real world issues that people are having with these kinds of claims.
It's really greater flexibility. It doesn't require
that's correct. And I was contacted by the Attorney General's office, and they have told me they have no concerns with the bill. They were just curious what the origin of it was, and I guess they didn't realize what some of the folks out in the trenches were facing.
All right, we have a question from Representative Bruce. Representative Bruce, do you have a question? And if so, will you unmute yourself, please?
Yeah, just a quick question. Is there a penalty if they're not in their office when the service comes?
No, sir. There's no penalty provided, but they're just statutorily required, and we presume they'll do their best to comply.
Okay, thank you.
Thank you for the question.
All right, I don't see any other questions. I'll hear a motion. This motion do pass and second on House Bill 1068 as introduced, LC 44-1877. Any further discussion, amendments? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? All right, it's on to rules. All
Thank you,
right.
Mr. Chairman.
Thank you very much.
Ladies and gentlemen of the committee. Mr. Chairman, if I may be excused.
Yes, sir.
Until
Thank
the
you so
meeting.
much. I know you have
Thank you.
other places to be. So next we'll call House Bill 1527, Representative Mathiak. If you'd like to come forward, please.
Good morning, everybody, and
morning.
thank you so much. We so appreciate it.
If you would just pull that microphone up so our members online can hear you. that'd
Yes,
be
sir.
great.
I believe that my judge from the Griffin Judicial Circuit is online, Judge Rita Kavanaugh. She is actually the one that brought this to me. And Your Honor, can you hear us?
All right, Judge Kavanaugh, we'll
Okay.
recognize you if you'd like to unmute yourself. Maybe you can assist Representative Mathiak in presenting House Bill 1527, please.
Let me see what she's saying to me.
Can you hear me?
Yes,
Yeah.
we can hear you and we can
Great.
see you as well. Thank you.
Thank you.
So Judge Kavanaugh, Representative Mathiak has brought us House Bill 1527, and we understand that it was an issue that arose in your Spalding County Court, and we'd love to hear anything about that issue that would be helpful for the committee members to understand the need of this legislation.
Okay, I have two constables in my court that serve the papers of the court. They serve all of the papers of our court except for the warrants, arrest warrants and the search warrants. They serve all the suits and the garnishments and execute all the writs, summonses, subpoenas, anything other than the criminal arrest warrants and the search warrants. I am down a constable that we lost back in January, and I've never had this problem come up before, but I can't find a constable to replace that one because one of the requirements to be a constable is you have to live in the county that you represent for at least 2 years. And had really never thought about it, but there's really no reason for there to be a residency requirement for a constable, considering what they do. Sheriff's deputies aren't required to live in the county, so the constable shouldn't be required to live in the county. I'm having a real problem finding a replacement for this position, although I have had several people come to me from other counties that were very qualified, but I couldn't hire them. The only thing it changes with reference to the eligibility for a constable is that residency requirement. That's the only thing that it changes. I do have this has been run by the leadership of the Council of Magistrate Court Judges, and they have no objections to it, and they are supporting this piece of legislation.
Thank you, Judge. So just so I'm clear, the other requirements that we're specifying for this office of constable, being at least 21 years of age, a United States citizen, a registered voter, and so on, and having a GED or a high school diploma, those are existing requirements. The only change here is the residency requirement. Is that correct?
That's correct. That's the only thing that is changed, is that residency requirement, which right now says residency for 2 years.
All right, any questions for the judge? Thank you very much, Your Honor, for being with us today. I don't see any questions.
Thank you.
All right.
Thank you.
So I want to also thank Brenda Cruz, the intern in our office, who's researched this issue, worked very hard on giving committee information about this. Are there any questions for the sponsor? All right, hearing none, I'll hear a motion. All right, there's a motion to pass and second on House Bill 1527 LC 490925. Any discussion or amendments? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? All right, very good. It's on to rules.
Thank you.
Thank
I
you so much
appreciate
for
it
being
so
here
much,
today.
everybody.
As I tell many of our members who come by Judiciary, don't let it get out how quick you were able to move your bill through Judiciary. We have a reputation to keep here, okay? So
Usually everybody goes, you're going to Judy?
Wasn't as painful as you thought it might have been. Yes. Yeah. Thank you for being here, Judge. That helps a lot.
All
right,
Thank you. I appreciate you.
Thank you, Your Honor. All right. So the final bill that we have before us is a committee substitute to House Bill 1390. And I'll ask Representative Nolowitz if you'll please come on up to the witness chair. And what I'll maybe do is just give you an opportunity as we begin, Representative Nolowitz. I know we had a several-hour hearing about House Bill 1389 and House Bill 1390. I know that there have been hours and hours and hours that everyone involved has spent meeting in the Capitol, meeting in this committee room.
I'm very comfortable in Judiciary at this point.
Yeah. Maybe you've been in here longer than you ever wanted to, but thank you so much for all of your hard work. And if it's all right, maybe I'll just turn it over to you to kind of give a summary to the committee about where your work has been so far and what conclusions you've reached as to what to present to us here today.
Absolutely. And I would like to start off with some thank yous also. I want to start off, first of all, thanking you, Chair Administration, for all of the support and insight and guidance you have given me through this process. I want to thank Paul Higbee, who has been fantastic. I want to thank Brock. Where is Brock? He is Brock. Thank you, right in front of me. Brock, you are terrific and an excellent meeting facilitator. This is Brock Perry. He's terrific. And Brenda, you have been invaluable in this process. Thank you very much. I want to thank the advocates who have been with me through this process, the Respect Georgia Workers Alliance, 9 to 5, the Ywca. I'm probably going to leave someone out, Grace Starling, Amanda Farahani. And I also want to thank ACCG and GMA. Their insight without their insight and without the many discussions and truly a relationship of mutual trust, I don't think we would be where we are today. And I'm so grateful for them. And I want to thank I want to give their I don't think they're here this morning, but the Georgia Chamber and the Metro Chamber, again, the commitment that they have demonstrated throughout this process. And I mean, Chair Administration is not underplaying this. It has been hours and hours and hours of meetings. Like we went from a couple of, several pages bills, and now I have this folder with every version and iteration and every sub that we have gone through in the past since we were here for that long hearing, which I thought was a wonderful hearing and conversation, I guess almost 2 weeks ago. So with that, and there is one more person I want to talk about specifically and mention by name, and that is Captain Tanya Gillavani with the Lawrenceville Police Department, because she is someone who, for reasons that I won't get into right now, she is not able to be here and speak for herself. We remember her attorney, Ed Buckley, was here with us when we had that long hearing, but the experience that she went through, her lived experience, which I know is not a unique lived experience. Again, Captain Tanya Gillavani, she is a lot of the reason, and what she has gone through is why we're here today. And I think it's really important as we have this conversation this morning, as we discuss the merits of House Bill 1390, which I'm about to tell you a little bit more about. We remember the humanity behind this legislation and the experiences of people, of workers in cities and counties, consolidated governments throughout the state, and what they have gone through, what they have survived. And that is my biggest motivating factor. So thank you all. With that, let's talk about the bill. Where we are right now with 1390, I'm working off of LC 442078 ERS. There are a couple of typos that we will talk about, but first I just want to tell you what's here, and then I'm open for discussion. I have some other experts with me if we have any questions that come up that require an answer beyond my ken. But we have, lines 11 through 23. This is going to be the definition of sexual harassment. I will tell you, I'll just go through the typos, as I said, and I also want to be very clear. These are my typos. A lot of this language, I literally was looking at one piece of paper and typing into an email to Legislative Counsel, and they're my fault, no one else's. But in line 13, we are going to strike comments or, so it will read sexual favors, sexual or sex-based conduct, or any other unwelcome and offensive conduct of a sexual nature. Further in the definition in line 17, we are going to replace the word a with the. So instead of reading submission to or rejection of the conduct is used as a basis, it will be used as the basis. And then in lines 24, we actually go into the cause of action. That's lines 24 through 43. And this is talking about, again, any individual working for a county, municipality, or consolidated government. We know that state employees already have these protections in place. And again, I'm going to take a moment to point out all of the insight that we were able to, and then the collaboration from GMA and ACCG and how important that was. In line 29 of this, reaction should be action. So you can strike the RE, just that little prefix. And then it should be, instead of against the individual in the terms of conditions, it should be in the terms or conditions of the work relationship. We are detailing, what is required for this cause of action. And then in line 37, we're going to add one phrase. It should read investigation, proceeding, hearing, or action related to sexual harassment, period. And I think that hits all the changes. And now I will, if you want to take a moment to look at that, or if anyone has any questions, anything they'd like to ask, I think we can start the conversation.
Well, thank you. And just to summarize for the committee, the only issue, please correct me, Representative Nolwitz, if I'm wrong here, but the only cause of action here is retaliation based upon report of sexual harassment.
That is correct.
And the relief is only that which is available currently under Title 45 for government employees.
That is correct.
All right. Okay, so what we'll do is first hear from our witnesses, and then if members of the committee have any questions for witnesses or the sponsor, we will hear those. First up is Charlotte Davis with GMA.
Thank you, Mr. Chairman and members of the committee. I'm Charlotte Davis with the Georgia Municipal Association, and I really appreciate the opportunity to be able to speak to House Bill 1390. First, I have to thank the bill sponsor, Representative Nolwitz. It's very easy when we have a former city official and former member of GMA come and ask for us to work together on a bill. We entirely appreciate the intent, direction, and what she's trying to do in state law, and we're completely supportive of the substitute bill. We've also worked really closely with our colleagues at ACCG. They were unfortunately not able to make it this morning, but did allow me to share that the counties are also supportive of the substitute. With understanding the intent that this is just related now to local governments, and as you ask, in the arena of retaliation, there were several ways that we could have gotten to this goal to achieve it, but we think that the substitute version that we have, we are comfortable with the definition of sexual harassment with the changes that have been noted, or striking the comments, and then the specific part, and Chairman, you already had referenced it, but it does tie back to the protections that are already laid out in the whistleblower protection. And the thought there was, we don't need to recreate a brand new system or procedural process when there's already something laid out that local government employees adhere to now. There's court action that would ensue, and there's also damages and relief that would be afforded to a person should a retaliatory action occur if they were experiencing sexual harassment in the local government arena. All that to say, I'll be happy to take any questions, but again, we would really appreciate the support of this committee to move this legislation forward, and are committed to continue to work with the bill sponsor as it does move through the process.
All right, thank you, Ms. Davis. You have a question, Representative Fleming.
Thank you, Mr. Chairman. You may or may not want to answer this, but it might be the chairman or Paul, but the definition of county, is this going to encompass school systems?
Yeah, my expectation is it will include all local government, including school systems. Yeah.
Okay.
So the application currently, Paul, you want to give it an opinion about that?
Yeah, Chairman, I will need to add a little language to cover that, but it's an easy fix. And
all right, well, I'll take back what I just said. So it does not include.
Yeah,
school systems.
I
Yeah.
was thinking it might not.
Yeah.
And I don't know if at this juncture, Chairman, we would want to add that in, because there are different federal guidelines, I believe, that affect the education because of some of the federal funds that they receive. I'm trying to search back in my memory, having handle some cases that dealt with this. So my suggestion would be probably not do that at this juncture.
Well, I know it's
But
a very
that's just my thought.
carefully reached, negotiated
Yeah.
outcome here today. Representative Nolowitz, are you asking to expand the scope of the bill here today?
I actually, no, I think we should.
If you would just use the microphone.
Yeah.
Oh, sorry. No, I am actually comfortable not including school systems. I agree that there is a lot more nuance to that aspect. I think it's meritorious, and I think it's a conversation that is worthy of having, but that is not the intent for this piece of legislation today.
All right. Well, thank you. Thank you, Representative Fleming, for your great question and clearing that up. Any other questions? All right, very good. Thank you so much for being here today, Ms. Davis. All right, next I have Michael Whitfield. Good morning.
Good morning. Good morning. Thank you, Chairman Estration and the rest of the committee. I'd like to express 9 to 5 support for 1390. My name is Micah Whitfield. I'm the state director with 9 to 5 Georgia chapter. Also, thank you, Rep. Nolowitz, for your support and leadership in this. We believe the bill will be supportive and good for our members and folks we know that work in city and county government. And we'd like to continue to work to expand the bill. Thank you.
Thank you so much. Any questions from the committee? Thank you so much for being here today. All right, and Elaine Hudson. I'm sorry. If you'd like to come on, it's great to see you, Elaine. Yes, it's great to see you again.
Good morning, everybody. Good morning, committee. As I've said, my name is Elaine Hudson, and I am the Director of Advocacy at the Ywca of Greater Atlanta, and where we are also a member of the Respect Georgia Workers Alliance. I would like to thank you, Chairman Estration, for your guidance and support on this bill. And of course, Representative Nolowitz, you've just been a dream to work with. I'd also like to thank GMA and ACCG and the many others who have collaborated and worked very hard on HB 1390. We believe this bill will help women and girls around the state. It has many benefits and will address many of the issues that we see. We are looking forward to continuing to expand upon this bill, but as it stands now, we are in full support of HB 1390, and we appreciate your time.
Thank you so much, Ms. Hudson. I don't see any questions. All right, very good. Well, we're now in a posture where I will hear a motion on House Bill 1390. All right, there's a motion to pass and second on House Bill 1390, Committee Substitute LC 442078 ERS. Just in the interest of time here, I'll propose a chairman's amendment to strike on line 13 comments or on line 17, change A to the. At the beginning of the first day, thank you. The first day. On line 29, change reaction to action and change of the first of to or. And at the end of line 37, add related to sexual harassment. All right, there's a motion or there's an amendment and second. Any objection to the 5 amendments? Hearing none, those amendments are adopted. All right, the bill's before us now. Any further discussion or other amendments? Hearing none, all those in favor of the committee substitute HB 1390 signify by saying aye.
Aye.
Any opposed? All right, it passes unanimously on the rules. Well done.
Thank you.
Excellent work.
Thank you.
Yeah. All right. Thank you so much. We're adjourned.